So what can you do? You know, as we've been talking about today so far, registration and collection is important if you're hitting those thresholds. But one thing to also consider is if you need to register with the Department of Revenue, you need to consider whether you need to also register with the Secretary of State. Because the Secretary of State, if you're actually doing business in the state, then the Secretary of State has filings that you have to do as well. So if you're selling into a state and shipping via common carrier, then typically you don't have to register with the Secretary of State. Any other connection will typically require registration because you're considered to be transacting business. Here are a few exceptions to that. I think you all have it. We don't necessarily have to go through them all in the interest of time. But this is the general rule. Some states are a little different, but generally they follow these definitions. So if you're not, if you're not transacting business in the state, if you're doing any of these things, you're not transacting business in the state. If you're doing more than these, then you have to register with the Secretary of State. And that's important to remember because sometimes those penalties are not very friendly. So we had one of our clients wanted to register in Illinois. Illinois was the example. And he realized that he had Nexus technically before this year. He had a new company, but he had a salesman going into Illinois last year. So we checked with the Secretary of State because he was wanting to register going back, and he was willing to do the sales tax returns for a year if that was necessary. He just wanted to be in compliance. We talked to the state, and they said, well, the penalty for him not registering last year is anywhere from $15,000 to $30,000. And that was a bit more than he wanted. So just know that those penalties can be significant. Potential penalties if you choose not to register, and sometimes there are situations where materiality, it's just not material, or I'm going to just accept the risk. And we realize that those are situations that companies have to consider. We may advise you one way, but you may choose to just accept the risk. Those risks will typically involve interest, non-filer penalties, transacting business penalties, which those are the Secretary of State. Fraud penalties, especially if you're collecting. We've had clients that have been collecting and just didn't realize. I had one client that just didn't realize that they needed to pay that to the state. They figured eventually they needed to collect the tax, but wasn't sure what to do with it.
And keep in mind, in most states, and maybe all states, if you collect sales tax or payroll taxes and you don't pay it over, there's personal liability for owners, for officers, for directors. It's a little bit different than other kinds of taxes because these states will pierce the veil and come directly to you for failing to pay over.
So if you're going to collect the tax, make sure you register first.
And then turn it over.
Yes, right.
Oh yeah, absolutely.
Right.
You don't want a trust fund penalty. It's called a trust fund penalty. You don't want a trust fund penalty.
Yeah, the states are not very friendly there because like I said, they consider that fraud. So they tend to frown upon you collecting it without being registered. So things to think about: where do I have sales tax nexus, whether it's physical or economic? If it's physical, then you need to consider a voluntary disclosure. If it's economic, you may be able to avoid filing a voluntary disclosure, but just know that if you do have physical nexus going back, then the state can always go back and get that. The more you get past the 3-year, 4-year statute of limitations in that state, they're less likely, but they can always go back because it's always open. So obviously you have to think about what states do I need to register in, what's the materiality, what states can I assume the risk, do I have a tax calculation engine, am I capable even of collecting the tax, and do I have my tax processes documented. So one thing that, when the case came out, it was on an online retailer. So most people thought, well, this applies to online sales, not sales that I might make into the state where I ship my product out there, where the customer may call me and buy, and I ship it. Just know that this new court case is not only applicable to online retailers, it's applicable to all sellers. Will there be a grace period for getting registered? Yes, typically. Once you hit those thresholds, you have about 30 to 60 days to register with the state. Will this remaining states enact the thresholds, as we discussed earlier? Yes, we expect them to do it within the next year. And when a company reaches the threshold, do they have Nexus going forward or next year? Once you reach the threshold and you have to register, you generally have Nexus going forward. If you're never hitting the threshold after that and you have no physical Nexus in the state, it's usually a 2-year period before you can deregister. So you'd have to file 0 returns for a couple of years. And then if you're not hitting the threshold, then you can deregister. But generally, once you have Nexus going forward. Will it be retroactive? Generally, no, but as Shelley said, if you have physical Nexus there, that is retroactive, and they'll go back as far as they need to. California, and what did you say the other state was? Florida is doing that. Even though Florida has no economic nexus statute, they're going after the physical nexus. And do non-taxable transactions count toward the thresholds? Generally, yes, as we showed you in the chart. I think we've picked on the income tax nexus quite a bit, but you have some protection under Public Law 86272, but don't be surprised if a lot of states go after it like Hawaii and North Carolina have done. Because when one state is successful with that, then the other states tend to be copycats. And will they increase audits? Probably, because they're getting all this new revenue that they never got before, so that gives them more ability to hire more auditors, which leads to more audits, which leads to a better chance of you getting caught.
So I fondly refer to this law and what's been going on for the last 18 months since Wayfair as, we can write a script for a movie called Catch Me If You Can, because that's how most people have been handling this. They're saying, oh gosh, you know what, I'm not dealing with it, let's see if they catch me. But I think the reality is it's going to change, because originally we thought the states wouldn't staff up, but the states see the economic opportunity and they're going at it. And I think that you'll start to see more states getting aggressive. And in the movie title after Catch Me If You Can, will include orange suits and stripes.
Yeah, and if you take that avenue of catch me if you can, then when you do get found, it's going to hurt.
Yeah.
So potential pitfalls, of course, penalties. We've touched on the amnesty, voluntary disclosure opportunities in the states. Amnesty is where the states have a certain period of time where you can register and they won't bother you going backward, or you can register and they'll take away the penalties, so it's not as painful for you. But generally you're not going to see, it's not going to be an amnesty period. You might find a state or two that's in an amnesty period, but they usually last just a few months. It's not an open amnesty generally. They'll institute ones, say, for June through September, So if you file in that time period, then you can get the advantages of an amnesty. Otherwise, you're going to have the penalties. Income tax economic nexus is a major pitfall as we get further down the road. I think there's going to be a lot of court cases on that, so that'll be fun to watch for some of us.
Yeah.
Tax returns will become due based on the date you start doing business in the state. So, practical things to consider. Norm, you want to start on this one?
Oh, sure. That's fine. Well, as we were talking about, do you want to get ahead of the curve? And a lot of the remote sellers and what have you, it's, as Shelley said, catch me if you can, and that's not a very healthy attitude to have on any compliance issue, whether it's IRS or state. And so you want to consider voluntary compliance with all of these rules as they come online. And as I said, if nothing else, it makes you a more attractive target for some takeover company if you're in the market to sell the company than it would have been otherwise. The streamlined sales tax agreement we covered, that can make things a little bit easier in terms of registration and getting forward, not that you won't get follow-up questions from the various states that belong to that. You want to go ahead and
this
switch?
KFC Corporation case, I don't want to get into it
Yeah.
too much detail. It was a 2010 case. It was in regards to KFC had franchises in Iowa, but they had nothing else in Iowa. They had franchises in Iowa, and so they got the franchise fees, but they didn't own the property in Iowa. They didn't have locations in Iowa because it was the franchisor, or the franchisee that had them, and they would pay the royalties to KFC. Well, KFC got dinged by Iowa because they have their labels on the chicken. They have, they're using their name, they're using their brand in the state, and so the state of Iowa was able to go after them for income tax.
So again, being ahead of the curve is in the client's best interest. Whether they do it or not is another question. Sometimes, in addition to what they can do to go after Amazon and Walmart and all these marketplace sellers, they can send the questionnaire directly to the client. And these are not to be ignored. The client should not just ignore it or try and fill it out themselves. They really need professional help when completing those, because one little thing off and they will use it against your client. So it's very important that if you do get the Nexus questionnaire that comes out, that you comply with the requests in a reasonable manner. And in my experience dealing with the IRS and various state departments of revenue is, if you deal straight with them, then they'll deal straight with you for the most part. You always get somebody who's not too nice or whatever, but for the most part, if they see that you're trying to comply and you're trying to figure things out, then they'll be very helpful for you. If you get into a situation where you're being dodgy with them and not compliance or whatever, then that'll get their attention. It's waving the red flag in front of the bull. And so you'll have state collection, and once they get that, they can make an assessment against that. They can reduce that to judgment. So this fellow in Philadelphia has to worry that California is going to reduce that assessment of $1.6 million to a judgment, register it in Pennsylvania, and start collecting on assets. So that's a big time risk. If it comes down to hard knuckle ball, and a lot of these states will do that. We never had a problem with the $1,000 guy. Somehow Ohio never got around to doing that. They tried to intimidate him into paying it, but they never got around to.
And just know, sorry.
No, go ahead.
And just know that there are still certain exemptions or loopholes that you can use. You do have the remaining constitutional defenses under complete auto.
Right.
We won't go into that. That can, that's best for an offsite discussion, but just know that you still have those protections.
Right.